Buckle up, guys. This one's wild. Today's video dives into 3 ridiculous courtroom moments featuring sovereign citizens. And get this, 2 of them actually showed up on the same docket. That's rare chaos. But before we jump into that madness, we've got an update on a familiar face. The woman who got arrested right in the middle of her previous hearing. Yep, she's back. And after her courtroom meltdown, she went full rant mode on Facebook. If you missed her earlier drama, no worries, I've linked those videos in the description. Let's dive straight into this disaster.
The court is on the record in City of Pontiac versus Amber R. McHenry, case number 24 TRD 527. Court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. We may have a resolution of the matter, should the court be willing to accept it, whereby the city would dismiss the fictitious plate charge at defendant's cost, and Ms. McHenry would then enter plea of guilty to the 2 remaining charges of failure to reinstate, driving under suspension, and expired plates. The city would then recommend whatever fines the court would deem appropriate along with the court costs of the case. Thank you.
Thank you. Mr. Sayage.
Thank you, Your Honor. I did convey the offer from Law Director Lewis to my client, Ms. McHenry, after extensive talks and going over what she would be waiving today. She has decided today that she would take the plea offer along with the state's recommendation of just court costs and fines.
Okay, Ms. McHenry, it's my understanding today that you wish to change, you originally entered no plea to charges of failure to reinstate an unclassified misdemeanor and expired plates, a minor misdemeanor. You wish to enter guilty pleas to those 2 charges. In exchange for those guilty pleas, the 4th-degree misdemeanor charge of fictitious plates would be dismissed at your cost. Is that what you would like to see happen today?
I believe so.
You understand by pleading guilty to those charges that you would be waiving your right to the jury trial that is currently scheduled at the end of the month, as well as all of your trial rights. We just had a trial last week, so you kind of know what a trial is like. So by pleading guilty to these 2 charges, you'd be waiving all of those trial rights. Is that what you wish to do?
Would that put an end to litigation?
Yes, it would.
Then no.
I'm sorry?
Yes.
Okay. Also, you are represented by Mr. Sayage. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes.
Okay. I do find that defendant's pleas of guilty to these minor and unclassified misdemeanor offenses in subcase A and B, failure to reinstate and expired plates, to be knowing, voluntary, and intelligent. The court will accept the guilty pleas to those 2 charges, and I will therefore find her guilty of those offenses. I will dismiss at the defendant's cost the fictitious plates charge in subcase.
Right, guys? Plot twist. After all her courtroom tantrums and that unhinged Facebook rant, she's now standing there admitting, yep, the law does apply to her. Shocking, right? But here's the thing. Is she actually owning up or just trying to fast-track her way out of trouble? Honestly, it feels more like damage control than genuine remorse, and the judge isn't falling for it. He laid down a clear warning: any more nonsense and things will get a lot worse. So, do you think she's finally learned her lesson? Me know below.
Ms. McHenry, I did not impose community work service. I could have. I did not impose a Class 7 license suspension. I could have on the failure to reinstate charge. I've just given you a fine and cost, although I'm ordering you to provide proof of insurance on the vehicle you're driving that day. If you're not able to provide to the clerk proof of insurance on the vehicle you're driving that day, you are subject to what we call a non-compliance suspension with the Bureau of Motor Vehicles. I guess what I'm saying, Ms. Henry, I could have sentenced you in a much more severe way. I did not. But understand that if you're back here with similar offenses and you're found guilty of those, I will impose those. What I didn't do today, I would do at a later time.
Right, guys? Let's see what happens next. We're headed to Georgia for a classic Judge Tammy Hayward moment. If you've watched her before, you already know Judge Hayward doesn't lose her cool. Even when dealing with the wildest defendants, she stays calm, respectful, but still makes sure they know exactly where they stand. And today's case is no different. Get ready for some firm, clear lessons from a judge who knows how to handle courtroom chaos without raising her voice. Let's dive in and see how she manages this one.
The next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Defiant Gresham, and Larry W. Johnson. All right, is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form
Ms. Turner,
56
Ms. Turner,
appointing judge.
Ms. Turner, I gotta see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right, so
Okay.
Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with the whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction with for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I represent Brian Widener as well as myself. I just want to point out to the court, this was initially filed and I was not named.
Okay.
And after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer for Mr. Widener.
Intended to name me too.
Exactly. Judicial immunity exists to protect judges from constant lawsuits simply because someone didn't like the outcome of their case. It lets judges make rulings without fear of personal retaliation. Same thing with attorneys. They're protected while representing clients, even when their arguments upset the other side. Without these protections, the entire legal system would get jammed up by endless personal lawsuits. It's not about shielding corruption, it's about keeping the courts running fairly and efficiently.
So, Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible, allegedly, for what you are contending happened. But then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
Exactly. At this point, it feels like she's treating the courtroom like her personal stage, not a place for serious legal matters. It's less about defending herself and more about getting attention, which is common with certain sovereign citizens. They'll ramble, repeat nonsense phrases, and ignore direct questions, all just to feel heard. But judges like Hayward have seen this before. She's patient, but she won't let the courtroom turn into a one-person show.